Hello everybody, let's begin with the criminal codes. Last video we had done the civil codes. Administration of criminal justice is carried out through magistrate courts and sessions courts. The Indian Penal Code together with other penal laws. Now I have told you what are penal laws, which give such some penalty or punishment or fine. Okay, India's substantive criminal law. Now what is substantive, what is procedural? You need to understand the basic difference. Procedural means which suggest the process or procedure of how to deal with cases, what are the powers of courts, how will a person file the complaint, what will all be there in that document, and all such stuff. And such are given in CPC for civil cases or CRPC for criminal cases. Fine. So these are procedural laws, and since it is only telling you the procedure, so these are not penal laws and will not give any penalty, punishment or fine for any wrongful act committed, but will only tell कि अगर ये एक्ट हुआ है तो आपको कैसे प्रोसीड करना है, कैसे किसी पर्सन को प्रोसिक्यूट करना है, उसके खिलाफ कौन से एविडेंसेस ऑन रिकॉर्ड लिए जा सकते हैं, एडमिसिबल माने जा सकते हैं. ठीक है. Like if I give you an example, what are the essentials of murder, which is an offense under IPC, that is given. All those essentials are given in IPC. Okay, once those essentials are proved, that means the offense has been committed. Okay, and that person will be called as an accused for the moment. Okay, so substantive means which tells you the substance, that what are the essentials which need to be fulfilled to refer or to infer that this offense has been committed. So that is under IPC. And procedure is, if that offense of murder is committed, how you will proceed with it, how will you prosecute that accused person, how will you file the complaint, charge sheet, how will you produce him before the magistrate, till what duration, what can magistrate do, फिर magistrate के सामने क्या क्या process होगा, उसका trial किस तरीके से लिया जाएगा, you can go to the crime scene or not, and if you are going to the crime scene, what all inquiries you can make over there, you can seize the weapons or not. ये सारा कुछ powers दिए हुए हैं CRPC में. Fine. So this is procedural and this is substantive law. This is the main difference. Substantive tells you the substance, that what are the essentials, and if those essentials are fulfilled, that means the offense has committed, and now that penalty or punishment, whatever is given, that can be awarded by the court after the trial stage is over, when the decision has to come, right? And CRPC tells you that how that all process will be done. ठीक. IPC सिर्फ तब तक काम आएगा जब तक आपको असेंशियल्स प्रूफ करने हैं. असेंशियल्स फुलफिल हो रहे हैं, अब वो आप प्रूफ कैसे करोगे, उसको कैसे कोर्ट में एडमिसिबल करवाओगे, ठीक है, दैट ऑल हैज़ टू बी गिवन, हैज़ टू बी डन अकॉर्डिंग टू CRPC. एंड ऑल्सो नाउ what we have is, these are all gone. IPC, CRPC, everything is gone. That has taken a back seat. Not a back seat as such, they will still be in use for some years, because cases according to these books are still pending, and criminal cases hai, so they will not have any retrospective effect. Whatever the laws will be at the time when the act was committed, those laws will be only considered. So अभी तो ये रहेंगे कुछ टाइम के लिए, but nevertheless we have in place of IPC BNS, in place of CRPC we have BNSS, and Indian Evidence Act also we have a new act of evidence, right? भारतीय साक्ष्य अधिनियम, भारतीय न्याय संहिता. ठीक है. Okay, so Indian Penal Code was of 1860. That means pre-independence era, right? Britishers made it after the first war of independence. So it was according to those English laws, according to their time period, their country, and whatever the situations or conditions were predominant in England, and whatever laws they needed post the first war of independence, when there was a lot of revolt against the Britishers, right? So very you can say, as you know, there were hanged to death sentences given to many Indians so that the revolt can be subdued, right? So IPC draws inspiration from English criminal law because it was made by them based on their conditions and has stood the test of time. It cannot be self-operative, means it does not operate alone. Okay, it has to be paired with something. Only essentials you can show by IPC, but how will you prove it? That is Indian Evidence Act. How will you proceed further to prove the innocence or to prove the guilty of a particular person, to prosecute him? What will you do? What are the powers of the court? What are the powers of police to arrest a person, to search and seizure a particular place or the crime spot for that matter? So all that has to be seen in relation to, or has to be read with some other statute. Some more has to be provided with it, or any substantive law for that matter, not only IPC, but any substantive law cannot be read alone. It has to be given with a procedure. Like I tell you, you can punish this person, okay, with this much penalty. If he commits a wrongful act, you may punish him with 3 years imprisonment or 10,000 of fine. But how will you punish him? आपको ये तो पता है कि आप पनिश कर सकते हो, बट कैसे करोगे? That is given in the criminal procedure code. So for that we have the sequels, or IPC has to be read together with CRPC and Indian Evidence Act also, okay, which guides for investigation and trial of criminal process. Categories of criminal courts. Courts of session. So this is section 9. Court is established by the state government for various sessions division. Court is presided over by a judge appointed by High Court of that particular state. High Court may also appoint additional sessions judge, assistant sessions judge. It has power to impose any sentence including capital punishment. Okay, so the hierarchy that we studied above in the previous videos, it showed assistant, it talked about additional sessions judge and assistant sessions judge, and above that the sessions judge. That is these three combinedly form the courts of session, and it is in section 9 that state government establishes and appointment is done by the High Court, right? Then CJM and additional CJM. And also we studied that who is the head of the state of criminal courts, head of the criminal courts, and head of criminal matters in the state, in the city. That also we did in the previous videos, right? So CGM in every district. Now it is very important, for every district we have a CJM, but for a metropolitan area we have metropolitan magistrate, that in short I denote as MM, okay, and this is CJM. Fine. So remember, CJM is for every district which is not a metropolitan area. That depends on whether there is a commissioner in the state, and that again depends upon the population of that district, okay, not state but district or city. High Court shall appoint a judicial magistrate of first class. Now as I told you that day, JMIC, judicial magistrate of first class, and JMCC, that is judicial magistrate of second class. JMIC is only CJM, okay, और इसके नीचे है ये JM2C. CJM may impose a sentence except sentence of death, imprisonment of life, imprisonment for a term exceeding 7 years. A chief judicial magistrate shall be subordinate to sessions judge, and every other JM shall, subject to general control of sessions judge, be subordinate to CJM. Now see the hierarchy over here. This court had the power to impose any sentence which included capital punishment, right? Sessions judge, capital punishment it can also impose, but over here it only can impose a sentence which is less than 7 years, which is less than 7 years. See what it is written: impose a sentence except death, imprisonment of life, and exceeding 7 years. So it can pass any sentence which is less than 7 years. So that will be its jurisdiction to deal with the offenses that have punishment of less than 7 years. Now since its power is more of capital punishment even, and its power is still 7 years, you can infer from here only what will be the hierarchy: sessions judge, chief judicial magistrate, and then every other judge in that city will be subordinate to CJM. Okay, and CJM के कंट्रोल में ये होगा, CJM इसके कंट्रोल में है. So indirectly this judge is also in the general control of sessions judge, right? Then Court of Judicial Magistrate. Section 11 CRPC states that in every district there shall be as many courts of first class and of second class, and at such places as the state government may, after consultation by High Court, by notification specify. So the powers are with High Court of that state and the state government of that particular state to establish as many court of judicial magistrates, first class or second class, in a particular area or under that state. Okay, and it has to be not a metropolitan area. Remember, JM जहाँ है वो metropolitan area नहीं होगा. If it's metropolitan area then we will have MM over there. Okay, मैं बार बार बता चुकी हूँ. Courts of Judicial Magistrate of first class are at second lowest level of criminal court structure in India. Why second lowest? Because just few minutes back I drew a structure: SJ, CJM, and CJM is JMIC only, that is Courts of Judicial Magistrate of first class. According to section 15, please remember the sections. A judicial magistrate is under general control of sessions judge and subordinate to CJM. In terms of section 29 CRPC, a judicial magistrate of first class may pass a sentence of imprisonment for a term not exceeding 3 years or of a fine not exceeding 10,000 rupees or both. So again, this is the power of judicating power of JMIC, that is judicial magistrate first class. What is the power? Sentence of imprisonment not more than 3 years, means less than 3 years, and 10,000 rupees से ज़्यादा नहीं होगा. ठीक है, ऐसे बनेगा ये. Okay, this is the power of JMIC, whereas the power of CJM is what? Not exceeding 7 years. Fine के बारे में कुछ भी mention नहीं है, so that means any amount of fine he can impose. Okay, so remember the sections 11, 15 and 29. Court at lowest level is called JM of second class, that is JM 2C. This court is competent to try the case if offence is punishable with imprisonment for a term not exceeding 1 year, fine not exceeding 5,000 rupees or both. Okay, so whatever above उसका आधा, 3 years से 1 year हो गया और 10,000 से 5,000. First class magistrate is competent to try offence punishable with imprisonment for a term not exceeding 3 years. In states such as Kerala, second and first class magistrate courts have been unified. Now this is another fun fact which you need to learn and underline as well. Okay, so in Kerala, first class and second class magistrate courts have been unified. In other places you will find at the lowest level second class, and the second lowest level, which was written above also somewhere, second lowest level is JMIC. Okay, Chief Judicial Magistrate can impose any fine, as I told you, and impose punishment up to 7 years. Assistant Sessions Judge is competent to impose punishment up to 10 years and impose any fine. Sessions judge can impose any punishment authorized by law, but sentence of death has to be subject to confirmation by the High Court. This is important. He can pass death sentence also. He can pass any punishment, that means including life imprisonment or death. But this death sentence, if he passes, since it's a lower level of court, so that has to be confirmed by the High Court, because it's deciding the life and death situation of a person. So it has to be confirmed by a court of superior authority as well. That's why we have confirmation by High Court, and for these you have to see section 28 and 29 CRPC. Okay, so one thing that you have to do in this is make a chart, write down court, okay, write down punishment, and in other column write down fine that it can impose. Okay, and you can also write the level as in level of the court. इसको यहाँ लिख लो rather, level of court. Okay, like this you have to make a chart or a table, whatever you can say, and you write sessions judge, assistant sessions judge, okay, CJM, JMIC, JM second C, ऐसे करके आप उसमें लिखो. ये हो जाएगा second lowest, then JM2C lowest, CJM below SJ, ऐसे करके आप लिख सकते हो. ठीक है, SJ तो हाईएस्ट अथॉरिटी है, हेड है of criminal courts matter. This is below SJ again. So in this way you can write down the levels, okay, so that you also understand the hierarchy over here. After that, punishment and fine, it's already given over there, so you can write down, and one more column here you can make, that is of relevant sections. Okay, so over here you can make the column of relevant sections. Okay, and then of course if you are making a table, then you have to learn it. Fine. Also, do not miss this fact of Kerala. Then we come on to Metropolitan Magistrate, were created by section 16 of the CRPC. Court of Chief Metropolitan Magistrate and those of Additional Chief Metropolitan Magistrate were created by section 17. Section 18 also provide for Special Metropolitan Magistrate. Towns having population exceeding 1 million could be declared as metropolitan areas. Metropolitan Magistrate is under general control of Sessions Judge and subordinate to Chief Metropolitan Magistrate. Okay, so like there was CJM, under whom we had JMIC and JM2C. So over here also Metropolitan Magistrate is under the control of Chief Metropolitan Magistrate, and they all are under the general control of Sessions Judge, since it is at the top. Okay, and this is of a city, of a district. And what is the criteria of declaring an area as a metropolitan area? Population exceeding 1 million. Okay, now what is the figure of 1 million that you have to find out in the Indian system? This is a British system of counting. Section 16, criminal procedure, section 17 and section 18, please remember it. Executive magistrates, every district and every metropolitan area, state government may appoint as many persons as it thinks fit to be executive magistrates, and shall appoint one of them to be the district magistrate. Executive magistrate means looks after the executive matters, administrative matters. Okay, and these magistrates, they look after the judicial matters. Fine, that is the difference between them. So in every district, let it be metropolitan area as well, state government can appoint as many executive magistrates as it deems fit, considering the population and other executive matters or other administration matters of that area, and one of them shall be the district magistrate, that is DM, belonging to the executive organs. As I told you, these officers work in tandem with police to maintain law and order. They are also responsible for judicial acts like traffic challans, registration of documents, sale deed, wills, marriage certificates, birth, death certificates. They are known as district magistrate, subdivisional magistrate, executive magistrate, special executive magistrate. Okay, nothing to explain as such. Then we will come on to types of offences, bailable and non-bailable offence. First of all, let me introduce you to the concept of bail. So I think you may have done a little bit of contract, and you know what is bailment first of all. If you don't know, then also you have to listen to here carefully so that you know what is bailment, and then I will take you to what is bail. Okay, so bailment means if there is a person A, or let take a simpler example. You go to tailor's shop to get your clothes stitched. Okay, what he does is he gives you a certain period of time that your clothes will be ready within this date, and you leave the clothes over there. Okay, and now the clothes are in the custody or in possession of the tailor. He has to take due care of the clothes that you have left, and also maintaining that quality. Okay, he quality as in उस पर कीचड़ नहीं लगाना, उसको गंदा नहीं करना, उसका रंग फेड नहीं करना कि इतना धो दिया कि वो, वैसे टेलर धोएगा तो नहीं, बट इवन इफ for getting for the chances of getting it shrinked if he washes once, so उसको इतना गंदा नहीं करना, उसका कलर वैनिश नहीं करना, उसको आयरन करो तो उसको फाड़ नहीं देना या उसको गंदी तरीके से स्टिच नहीं कर देना. ठीक है, एंड ऑल्सो ही हैज़ टू टेक ड्यू केयर ऑफ द क्लॉथ्स दैट it doesn't gets lost from his possession, otherwise he will be responsible. Okay, so this is the concept of bailment, wherein you are giving your item or your belongings to another person, and he has to take care of those items until a specified period of time that is pre-decided. Okay, that duration is pre-decided between the parties, and on expiry of that duration of time, the item has to be returned back to the person who was the owner of those items. Okay, so that is bailment. Now remember this, you are giving something to somebody for a specified period of time, and after the lapse of that period, that item has to return to you. Fine. Okay, now that means your ownership has not lost, only the item was in possession for a certain period of time under another person. Fine. This can also be related to your act of taking notes from your friends or classmates. Okay, you take their notes book, you go to your home and note it down, and then you give it back to him the next day. Right? So this is what? This is also a concept of, you can say that it is an example or concept of bailment, wherein one person is giving you the other item for a specified duration, and now since it's in your possession, you have to take care of it. अपने सामान का तो जितना ध्यान रखते हो उससे ज़्यादा ध्यान आपको दूसरे के सामान का रखना, बिकॉज यू आर नाउ रिस्पॉन्सिबल फॉर इट. ठीक है, अगर वो खो गया तो वो बंदा आपसे जवाब मांगेगा कि मेरा कहाँ गया, अब तुम वापस से मुझे लिख कर दो. जब भी कोई आपको कोई चीज़ देता है, या इवन इफ़ यू गिव इट टू समबडी, व्हाट यू से, खोना नहीं चाहिए, जैसा है वैसे वापस दे देना. So what is this? You have to take due care. You are giving the instructions. Okay, so this is only the concept of bailment. Now, from this bailment comes the concept of bail. Okay, now bail is what? It is related to jail. A person is imprisoned for a certain period of time, but there are some medical conditions due to which he has to seek some medical advice, and for that he has to go to a hospital. It is needed, it is the requirement of its health condition has deteriorated, that his visit to the hospital is mandatory now, without which he cannot be in a safe health condition. So for going to hospital he needs some leaves from this jail. ठीक है. Okay, now what will happen? The matter will go to the court, he will apply for bail, the matter will go to court, it will decide according to its discretion. For some days it will give the bail to that criminal or to that person who was arrested, who was accused. Okay, now suppose the bail is granted for a period of 10 days, and his imprisonment is for a period of 7 years. Now this leave of 10 days does not mean that he is acquitted from the case, or the allegations have been washed away, or he is or his punishment of 7 years has been over, even if this bail is for 1 year. Okay, if this bail is for not 10 days but 1 year, that doesn't mean कि उसका ये 7 ईयर वाली पनिशमेंट ख़त्म हो गई या कम हो गई, उसकी पनिशमेंट अब 6 साल है, ऐसा नहीं होगा. His punishment will remain 7 years. He has to spend these 7 years in jail, no matter how many days his bail was. He has to be present on the lapse of this duration and has to surrender himself into the jail again. So you can relate it to the concept of bailment. The person goes out for a certain period of time, and at the lapse of that period he has to return to that place. Okay, I'm not comparing persons to items, but this is how the concept works. And there is nowhere this bailment, nothing is defined in CRPC or IPC or in any criminal statute. Okay, so we take it as the general meaning. There is no definition of it. Bailable offences mean, as the word itself suggests, bailable. You can divide it into two. Bailable, bail होने के लायक. So those offences in which you can claim bail as a matter of right. You means accused. Okay, so bailable offences are those in which bail can be claimed as a matter of right. Okay, but non-bailable, which cannot claim bail as a matter of right. This does not mean that bail cannot be granted at all in those offences or in those cases. It is granted, but there are many conditions put forward. Even in a normal bail for bailable offence, conditions are put forward that on the lapse of this period you will be present. Whenever court asks for your summon, you will be present. You have to cooperate with the court proceedings. Okay, and you have to surrender yourself. You don't have to go outside the territory of India or the territory of city. So you have to submit your passport. All these conditions and many other, as per the circumstances of the case, has to be fulfilled by the accused if he wants his bail to be granted. Okay, so it is same to the instructions as you give. Even if you give your cloth for stitching to a tailor, you give him instructions that I want this to be stitched in this pattern, right? And you have to take due care of that. It is understood basically. The object of detention of an accused is to secure his or her physical appearance at the time of trial and time of sentence if found guilty. Now, why we arrest the person? Why we keep him in custody? There are two things. First, though, it is mentioned over here only to secure his physical appearance, that वो मेरी custody में रहेगा, तो जब भी उसका डेट होगा कोर्ट में, हम उसको आसानी से प्रोड्यूस कर देंगे. लेकिन अगर वो कहीं बाहर है, हमारे डिटेंशन में नहीं है, तो क्या हो सकता है दैट ही में मिस आउट, ही में मेक सम एक्सक्यूज़ के नहीं आ रहा मैं, या वो उसी दिन कंट्री से या सिटी से बाहर चला जाए. सो देर आर चांसेस दैट ही विल एस्केप to be physically present at the time of trial or the time of date of the court. When summons are issued to him, he may ignore that. So to secure that, to ensure that the detention is done. Okay, and at the time of sentence also, if he is found guilty, since accused का trial होगा तभी तो उसका guiltiness या acquittal होगा ना. Also, it is to, since he may have committed something that is a wrong against the whole society, since we are dealing with crimes right now and they are considered to be wrongs against the society. So it may happen that he may have he had done some act which is against the whole society. So if he is moving or roaming freely into the society, into the general public, then there are chances he may commit the act again and cause danger to the general public. So to avoid that also, detention is done. To secure peace and order in the society also, this has to be done. Grant of bail has been a matter of judicial discretion. As I told you, the matter goes into the court. A person files for bail, that is accused files for bail application, and the matter goes into the court, and according to the discretion of the court, bail may be granted, bail may not be granted, and or kitne din ki hogi, that is also purely the discretion of court. Supreme Court held that bail covers both release on one's own bond with or without sureties. Own bond without sureties. अब इसका मतलब आप समझ लें, As I told you, there are many conditions which are put forward that needs to be fulfilled if person wants that he is granted bail and he is set free for a certain period of time. Okay, but this bond means that वो अपनी गारंटी खुद ले रहा है कि अगर मैं इस पीरियड के बाद नहीं प्रेजेंट हुआ, मैंने सरेंडर नहीं किया, तो आई विल बी लाइबल टू पे दिस मच अमाउंट, or you can attach my property worth this. So on his own bond, on his own guarantee. With or without sureties, sureties are the persons who take guarantee, the third person who take guarantee of the accused that मैं इसको यहाँ लेकर आऊँगा, मेरी गारंटी पे आप इसको छोड़ दो, मैं इसको यहाँ लेकर आऊँगा, जब आप बोलोगे तब लेकर आऊँगा, ठीक है. सो इट कैन बी विथ श्योरिटी और विदाउट श्योरिटी. और इस श्योरिटी के साथ भी हम कुछ मनी और प्रॉपर्टी अटैच करने का लिख सकते हैं कि अगर श्योरिटी ने भी अपना वादा नहीं पूरा किया तो उससे इतना हम ले लेंगे और उसकी इतनी प्रॉपर्टी अटैच कर लेंगे. सो दैट इज़ विथ और विदाउट श्योरिटीज़. आई होप इतना समझ में आया है. नहीं आया तो नो नीड टू वरी, दिस इज़ द बेसिक कॉन्सेप्ट. इससे ज़्यादा इजी लैंग्वेज और छोटा मैं नहीं बता सकती. सो यू हैव टू स्टडी दिस इन डिटेल इन CRPC. CRPC has classified all offences. Now where are these offences given? IPC. Since that has to be read with substantive law, this procedural law has to be read with substantive law, that is IPC. So these offences are in under IPC. Okay. First schedule read with section 2A of CRPC. 2A defines bailable offences. It can be generally stated that all serious offences, offences punishable with imprisonment for 3 years or more, have been considered as non-bailable. This general rule can be suitably modified according to specific needs. Now, this term generally stated, anywhere it is not defined नॉन बेलेबल ऑफेंसेस. सेक्शन 2A में बेलेबल ऑफेंसेस दिया है, नॉन बेलेबल कहीं भी डिफाइंड नहीं है. सो अकॉर्डिंग टू दिस डेफिनेशन वी कैन इन्फर, वी कैन कंक्लूड that all serious offences punishment of 3 years or more have been non bailable. ये कहीं भी क्राइटेरिया CRPC में नहीं दिया है. We are just generally concluding it. Okay. And this can be modified. That's why it's not given in the statute. It is not statutory guaranteed. So it can be modified according to the needs. Okay. If a person accused of a bailable offence is arrested or detained without warrant, he or she has a right to be released on bail. Since he has committed a bailable offence, so as a matter of right he can be released. As I told you, bailable offence में as a matter of right bail grant करी जाती है. Okay. If the offence is non-bailable, does not mean person accused shall not be released. In such a case, it is a matter of, bail is not a matter of right but a privilege to be granted at the discretion of court. This I had already told you. Power to cancel bail has been given to the court and not to a police officer. Now as I told you, court may grant, court may cancel according to the facts and circumstances of case or the behavior of the accused. बहुत वायलेंट रहा है जेल में, तो फिर कैसे ग्रांट करेंगे? इफ़ देर आर चांसेस कि वो पावरफुल है, वो बाहर निकलते ही एविडेंसेस के साथ टैम्पर कर सकता है, डिस्टर्ब कर सकता है, या फिर विटनेसेस को धमका सकता है दैट मेरे खिलाफ बयान मत देना, दे दिया तो समझ लेना फिर तुम. सो इट मे हैपन, दीज केसेस, दीज चांसेस आर हाई. सो उन सर्कमस्टांसिस में बेल कैंसिल भी करी जा सकती है. एंड इट इज़ द पावर ऑफ कोर्ट. सिंस द मैटर गोज टू कोर्ट, इट इज़ द पावर ऑफ कोर्ट. पुलिस ऑफिसर कैन नॉट कैंसिल इट. ओके. जिसने ग्रांट की है वही कैंसिल कर सकता है. ठीक है. Also, bail can be cancelled at any moment after it is granted. For suppose bail was granted for 1 year, but after 6 months it is found that there are serious consequences or the person has violated any of the conditions. Okay, any of the conditions are violated by the accused. कि हमने जो कंडीशंस रखी थी उसमें से ये दो इसने वायलेट कर दी हैं, तो अब क्या करें? अब हम बेल कैंसिल कर देंगे कि वापस आओ, दी थी हमने 1 साल की, बट नाउ आई एम कैंसलिंग दैट. ओके. दिस इज़ जस्ट एन एग्जाम्पल. द कोर्ट कैन ऑल्सो, वन थिंग इज़ टू कैंसिल बेल विच इज़ ऑन वायलेशन ऑफ एनी कंडीशन, अनदर थिंग इज़ टू रिफ्यूज़ टू गिव द बेल, और अनदर थिंग इज़ टू ग्रांट द बेल. ओके. Next, anticipatory bail we will do in the next class.